173 years. That is not a typo. That is not clickbait. That is the United States government's own estimate for how long it could take before asylum seekers can get work permits again in this country. On Friday, February 20th, the Department of Homeland Security published the most aggressive proposed rule change to asylum work authorization in decades. If this rule is finalized, every single asylum seeker who applies for a work permit starting this year will be told no, not denied on the merits, just told the system is frozen and there is no timeline for when it reopens. 1.4 million pending asylum cases. Hundreds of thousands of people currently working legally in the United States on asylum-based employment authorization documents. Employers in restaurants, hospitals, construction sites, warehouses, farms, and factories across the country who depend on these workers. All of them are about to be affected. If you have a pending asylum case, if you have an EAD based on a pending asylum application, if you employ someone who does, or if you are thinking about filing for asylum in the United States, you need to watch this entire video right now. I am breaking down exactly what the proposed rule says, who it affects, who is safe, and what you need to do before this goes into effect. Welcome to U.S. Immigration News Daily, your source for verified updates and clear guidance on United States immigration. I cover USCIS updates every Monday, Wednesday, and Friday at 2 p.m. Eastern. If this is your first time here, subscribe so you never miss a critical update. Let us get into it. Here is what DHS proposed on February 20th. Change number 1. The waiting period to apply for a work permit based on a pending asylum case is being doubled. Under the current rule, asylum seekers can apply for an employment authorization document called an EAD after their asylum application has been pending for 150 days. They become eligible to receive the work permit after 180 days. The proposed rule extends the waiting period from 150 days to 365 days. That means you would have to wait a full year after filing your asylum application before you can even submit the work permit application. And then USCIS has up to 180 days after that to process it. So the earliest you could realistically get a work permit would be a year and a half after filing for asylum. Change number 2. This is the one that changes everything. DHS is proposing a system-wide freeze mechanism. If the average processing time for affirmative asylum applications exceeds 180 days for 90 consecutive days, USCIS will pause acceptance of all new asylum-based EAD applications. All of them. Not just new applicants. The rule also affects renewals. If you are watching this and thinking that sounds like it would be triggered immediately, you are correct. The current average processing time for affirmative asylum applications is over 1,200 days. That is more than 3 years. The threshold to trigger the freeze is 180 days. The freeze would begin the moment this rule is finalized. And here is where the 173-year number comes from. DHS itself estimated in the proposed rule that it could take between 14 and 173 years for processing times to drop below 180 days. That range depends on how many new asylum applications are filed and how quickly USCIS can work through the backlog of 1.4 million pending cases. If this affects you or someone you know, hit the like button right now so this video reaches every person who needs to see it before the comment period closes. Change number 3. Migrants who entered the United States without inspection, meaning they crossed the border without going through an official port of entry, would generally be barred from receiving a work permit. There is one narrow exception. If you entered without inspection but reported to border authorities within 48 hours and expressed a fear of persecution or torture, you may still be eligible. But if you crossed and were later apprehended days or weeks after entry, this proposed rule would bar you from work authorization. Change number 4. The proposed rule ties EAD eligibility to the 1-year asylum filing deadline. Under current law, asylum applicants must file within 1 year of arriving in the United States unless they qualify for an exception. The proposed rule would make this deadline an additional requirement for work permit eligibility. If you missed the 1-year filing deadline and do not qualify for an exception, you would be ineligible for an asylum-based EAD even if your asylum case is still pending. Change number 5. Biometrics would be required for every initial and renewal EAD application. Currently, biometrics are sometimes waived. Under the proposed rule, Every single applicant would need to submit fingerprints and photographs, adding additional processing time and potential delays. Now let me be clear about what this is and what it is not. This is a proposed rule. It is not final. It is not in effect yet. The current rules still apply until the final rule is published and takes effect. DHS published this as a Notice of Proposed Rulemaking. There is a 60-day public comment period that begins when it is published in the Federal Register. Anyone can submit comments for or against the rule during that period. After the comment period closes, DHS reviews the comments and may modify the rule before issuing a final version. The entire process from proposed rule to final rule can take months or even years. But do not let that make you complacent. This administration has moved fast on immigration changes, and USCIS has 1.4 million reasons to push this through. Comment below and tell me your situation. Do you have a pending asylum case? Are you waiting on an EAD renewal? Are you an employer? I read every single comment. Here is who is affected and who is not. If you already have an approved asylum case, meaning you were granted asylum, you are not affected by this rule. Granted asylees have a separate work authorization category. This rule targets people with pending asylum applications who have not yet received a decision. If you have a pending asylum application and currently hold a valid EAD, your current work permit remains valid until its expiration date. However, when you apply to renew it, the renewal could be frozen under the new processing pause if the rule is finalized. If you have a pending asylum application and have not yet applied for an EAD, the current rules still apply today. You can still apply after 150 days. But if the final rule takes effect before your waiting period is up, the new 365-day waiting period would apply to you. If you entered without inspection and have been in the country for more than 48 hours without reporting to border authorities, the proposed rule would bar you from asylum-based work authorization. If you are a TPS holder, a green card applicant, an H-1B worker, or hold any other immigration status, this rule does not affect your work authorization. This is specifically about asylum-based Category C-8 EADs. Here is what you should do right now. Step 1. If you have a pending asylum case and are eligible to file for an EAD today under the current 150-day rule, file immediately. Do not wait. File Form I-765 with USCIS as soon as you are eligible. Get your application in the system before any final rule takes effect. Step 2. If your current EAD is expiring in the next 6 months, file your renewal application now. Do not wait until the last minute. USCIS processing times are already long, and if the freeze mechanism takes effect before your renewal is processed, you could lose work authorization. Step 3. Gather your documentation. Keep copies of your I-94 arrival record, your asylum receipt notice, your EAD, and any correspondence from USCIS. You will need proof of your filing dates and entry dates. Step 4. If you entered without inspection, consult an immigration attorney immediately. The 48-hour reporting exception is narrow and documentation requirements are strict. An attorney can assess whether you qualify. Step 5. Submit a public comment. The 60-day comment period is your legal right. Go to regulations.gov and search for the rule by its RN number 1615-AC97. Your comment becomes part of the official record that DHS must review. Step 6. Talk to your employer. If you work on an asylum-based EAD, your employer needs to understand what is coming. They need to plan for the possibility that your work authorization may not be renewable. Having that conversation now, while your EAD is still valid, is better than being surprised later. I covered TPS terminations for Honduras, Nepal, and Nicaragua in my last video. Many TPS holders whose status is ending may be considering asylum as a backup. If that is you, understand that this proposed rule could eliminate the work permit pathway that makes asylum viable for many people. Watch my TPS video linked in the description to understand all your options. Share this video with every asylum seeker, every immigration attorney, every employer, and every advocacy organization you know. The 60-day comment period is the one window where the public can influence this rule. People need to know about it. Subscribe and turn on notifications. I cover USCIS updates every Monday, Wednesday, and Friday at 2 p.m. Eastern. Drop a comment below and tell me how this rule affects you. I read every single comment, and I will see you in the next video.